Good afternoon, everyone, and welcome to our presentation today, e-discovery issues that affect your practice. Our presenter today is Mr. Sean Houston, founder of Legal Support Partners, an expert e-discovery technology company which focuses on reducing the cost and complexity of e-discovery services. Sean has worked on numerous high-profile cases, including governmental second requests, federal and state investigations, SEC, and FINRA cases, Enron-related criminal and civil litigation, WorldCom bankruptcy litigation, and other highly publicized civil and criminal matters. The TASA Group has provided expert witness services to the legal community for over 58 years. We have now partnered with Legal Support Partners to provide e-discovery solutions for attorneys to help manage electronically stored information throughout the litigation life cycle. Mr. Houston currently acts as an advisor on multiple cutting-edge legal software technologies that address the needs of discovery teams and solution providers. During our presentation today, you can use the chat feature, which is located to the right of your screen, to submit questions for Sean. And toward the end of the presentation, we will take a question and answer break for Sean to answer any questions that you may have. And now, Sean, I'm going to turn the presentation over to you.
Carol. Hello, everyone. Good afternoon, and thanks for joining our webinar here. Today, we're going to be discussing some issues around e-discovery, and one of the reasons that we wanted to have this discussion today as a follow-up to the CALA event in Las Vegas was because there was a lot of interest from the attendees around e-discovery issues and how those issues are affecting their practice. So, as many of you may be aware, data is more accessible than it ever has been. In fact, there's data being created constantly, whether even through webinars like this. People create data on smartphones, laptops, PCs, servers, phone systems. Data really is everywhere. And a lot of the communication that your clients are having are happening digitally. So whether it be through text messages, social media, email, even VoIP phone systems, the communication generally is happening digitally, no matter where your clients are located. And whether you realize it or not, all these things come together mean that your clients are leaving trails of discoverable information wherever they go. So, that information, can exist in a number of places. So that's one of the reasons that I think there was a great interest, because more and more parties are becoming savvy to that information existing out there in the world, and that they may want to request it during discovery. On top of that, the ABA model rules had a change fairly recently where there's an expectation on attorneys that they keep up to date on relevant technology. And it doesn't necessarily mean that create the expectation that attorneys are experts on every area. But there is the expectation that attorneys be conversant on technology, and that includes electronic discovery technology. One of the hot topics in the e-discovery world right now are the proposed federal rules of civil procedure changes and how they might affect e-discovery. There's 4 separate sections that particularly make comment on e-discovery and relate to e-discovery matters. There's other changes as well, but we're here today on electronic discovery-related items. So the proposed changes are currently out for comment. I believe the comment period is still open. The rules haven't been adopted yet, but some of the items include a change to Rule 1, which mentions cooperation amongst parties, which, especially on the federal level, the courts are pushing to help, number one, reduce costs, but number two, to also help keep the trial schedule moving and hopefully speed up the discovery process and the trial process as a whole. Rule 26B and 26C, the comments or the proposed rule changes there, the goal of them is to hopefully draw some lines when it comes to proportionality, as Rule 26B, and cost sharing, as Rule 26C, to hopefully reduce the cost of e-discovery. As you may know, the e-discovery and discovery in general the amount of data has been increasing, which can also directly increase the cost associated with e-discovery services and discovery. So those two items hope to instruct to give the court some guidance in terms of where to draw the lines for proportionality and when the costs should be shifted to other parties. And then the final rule, proposed rule change that may affect e-discovery, Rule 37 in regards to sanctions. And that's the specific language in the rule changes is sanctions may be imposed if failure to preserve information caused substantial prejudice in the litigation and were willful or in bad faith, or irreparably deprive the party of any meaningful opportunity to present or defend against the claims in the litigation. I think it's to hopefully rein in some of the potential sanctions. I think that's why they included the language in there about causing substantial prejudice in litigation, and it was willful or in bad faith in terms of any spoliation of evidence. However, I think it should be noted that they used the word "or" instead of "and." So if one party is irreparably deprived of a meaningful opportunity to present or defend themselves, that may lead to sanctions as well. And just to make a note, if there's any questions as we go along, feel free to put them in the chat feature, and we can answer the questions as we go, if it's relevant to the topic we're discussing at the moment, or we can address questions at the end.
Sean, let me ask you this, since if you go back to that previous slide, when do we think that these changes are going, or when are they going to take a look at these changes and perhaps pass them, since they're only proposed at this point?
Like I said, I believe they're still under consideration, open for comment. I think we're looking at probably in terms of when they would be implemented. We're probably still at least a full year away from that.
Okay, thanks.
I mean, again, one of the major issues that the proposed rule changes came about related to e-discovery is due to proportionality and cost shifting. Obviously, cost is a huge issue concerning e-discovery, whether rightly in some cases or it's just a kind of existing long-term perception. The cost is still can still be fairly high in proportion to a case. So these are two main issues that are still kind of weighing on the legal profession and the e-discovery profession as a part of the legal profession. So the question obviously comes up fairly frequently: how much data is too much? And those issues, it's going to depend on the case. And unfortunately, when it comes to e-discovery, there's a common refrain you may hear is it depends. And it's because each case is different. The data related to each case may be slightly different. How the data was stored, how accessible it is. So it's going to depend on your particular case. So the first issue is how broad is the litigation, and how broad does the litigation hold need to be. And the amount of data, again, as we said, with all communication being digital, just continues to balloon. And the proposed rule changes, I think we're all hoping will affect some of the cost issues associated with proportionality and the cost of e-discovery. Some case examples of where proportionality and cost shifting were addressed by the court. One from last year that was of note in the Eastern District of Pennsylvania was Judge Bailson's discussion and order regarding a discovery fence. That was his term used. And in that case, he created essentially a fence around the discovery for the case. And the fence, he described it as movable. So if new facts were identified about the case, then the fence could move to adjust to that. But if something was found to be outside of that fence, then the requesting party would be ordered to pay for that discovery. And I think the general theme of it was to try and put some walls, some theoretical walls around the discovery that was coming into effect. And it was a case around LA Fitness being sued for membership fraud, essentially. So, and that was one example of where it was very clear in terms of what was proportional and what didn't fall under the proportionality rule. But there's other cases as well where that other judges have essentially disagreed and put the onus on the defendant. And Fleischer v. Phoenix Life is one of those cases. And then there's cases where discovery has been blocked by the court. Apple v. Samsung is an example of that, where there was documents that Samsung was asking for, and the cost and effort for Apple to retrieve those documents was so much that the court decided that other information that Samsung already had in its possession that was produced by Apple was sufficient, and they didn't need to produce other documents related to the issue at hand. In terms of how much data is too much, here on this slide, we're trying to give some averages in terms of units of measurement from the data side and what they equal into the pages. So, for instance, if you have 1 gigabyte of data, which it would equal to roughly 75,000 pages. And to put that into perspective, I think the new iPhones, I think the smallest size hard drive on a new iPhone today is 16 gigabytes. So if you do the math out, it potentially could hold quite a bit of data. And we see more and more smartphones, from the iPhone to the Android phone, such as the Samsung phone, get pulled more and more into discovery. So it's just to give you an idea of how much the data, whether you're requesting it, could turn out to be in terms of what gets produced to you, or if you have to produce to the opposing side, how much data it might turn out to be. And there's ways to affect these numbers, obviously, with some filtering options to hopefully winnow down some of these numbers and some of the volume associated with e-discovery. But these are good average estimates to use going forward. Obviously, we've talked about why we should be thinking about e-discovery, issues about proportionality. But when you get into the case, when do you start thinking about e-discovery? And in my experience, it should be early in the case. The earlier, the better, in fact. E-discovery is a great way to do fact-finding for your case. Some of the first things you should be doing would be to identify individuals relevant to the litigation, find out where their data is. I usually recommend to clients to create a data map. Now, there's some software programs that exist to create data maps. However, even for small cases, even if it's just a matter of creating a spreadsheet and listing for each custodian where they store data, where they store their email, what email systems they use, what network shares, if they work for a company, what network shares they have access to. If an individual is in sales, for instance, do they use tools such as Salesforce that might be subject to litigation? So that way you have a clear idea of where the data exists that these people use, so you know you can make some decisions going forward if any of that should be pulled into the litigation, or subject to, at the very least, subject to a legal hold to make sure the information is preserved. Now, one thing that talking to plaintiffs' lawyers that I see a lot is it's important to make sure that you have your own house in order early on, so that way if you need to push the defendants to produce and seek any relief from the court if they haven't preserved data, that you have your house in order as well, so you're not pushing for something that you didn't do yourself. Again, whether it be email or text messages or phone or social media information, sometimes it's important to keep that information readily available on your own side. Again, so that way you can the defendants can make an argument that you didn't do the same. And all parties should consider whether data exists in third-party systems. So if data exists in a system, cloud-hosted systems such as Dropbox, Gmail accounts, Facebook, Twitter, make sure that that information is preserved and won't be destroyed just through the ordinary course of business. So that way that information is preserved. So that's one thing that should be asked fairly early on to make sure that that information isn't accidentally lost. The question comes up: where do you look? Where is all this data, and where potentially could it exist? Email is still quite a significant treasure trove of discovery information, and email. A lot of people don't realize email can exist in multiple areas at once. So you can have email on your laptop, on your smartphone, on your iPad, and at the same time, it could exist on your work computer or in the web server or the email server for your email system. And each of those different items could potentially have different pieces of email. So even though I deleted it from my laptop, that email still may exist on the email server. Or if I deleted it even from the email server, depending on my email system, it may still exist on my smartphone if I had downloaded it and updated the email on my smartphone. So that's something to consider. A lot of times we see people pick and choose where they decide to gather the email from. It depends on the specifics of your case. And the reason that people pick and choose goes back to the proportionality issue. Obviously, collecting data, from 2, 3, 4, 5 different sources, and then comparing it to get the full picture of email can be expensive. So that's one thing to consider. But also smartphones, we mentioned, text messages, email, photos can be gathered. Even potentially deleted text messages or items from smartphones can be gathered. Location data could potentially be significant to a case. If you're dealing with network servers, so shared drives, things like Microsoft SharePoint could hold information related to your case. And the cloud is a kind of growing presence that, in my experience, we don't see a lot of, but with the general adoption of tools like Dropbox for personal and business use, that's an area that I see that will be growing in e-discovery. And then structured data, unstructured data would be things like user-created documents, Word documents, spreadsheets, things like that. And structured data is data that's integrated into a system, databases, proprietary systems. So that's where each document is related to another document. And then finally, social media is a big and blossoming issue in its own right. But within e-discovery and the law, there's multiple ramifications. Whether you're on the defense, whether you're a plaintiff attorney, social media has the potential to be used either for or against your case. One thing to note is that I think amongst the general public, there's still a question of whether social media, things like Facebook, Twitter, Google Circles, is discoverable. And I think there's no question that the courts have spoken and it is discoverable. In the last couple of years, it seemed like the courts were on the defense and a little hesitant to go full bore and not put any privacy restrictions on it. But I think, from what I've seen, anyways, the cases coming out tend to lean towards allowing discovery of social media more than not. So, that's something to be to keep in mind as a potential issue for your case. And obviously, if it is an issue in a case you're working on, there's always a question of how do you get the data. So, there's the one option is giving a subpoena to Facebook or Twitter and asking them to turn over any information. However, it seems to me that they're not too happy about doing that and like to avoid becoming the middleman, like to push back on those requests. One of the most frequent ones that we see lately is just getting the user credentials from the custodian who owns the account and going about it that way. And if it may be necessary to get a court order to do that, but that's something that we see fairly often. Facebook also has, and that's Facebook, I think I talk mostly about because it's the one that we see most often coming up as an issue when it comes to social media, because so many people use it on a regular basis. Facebook has an option to actually download the entire content of your account. So that may be a way to get it. There's also website snapshot services and tools that can grab that information. But one thing to also consider is that social media, depending on the privacy settings of the account, may be readily accessible to the general public. So with a simple Google search, or going to Facebook and just searching on a name, you may be able to see the entire content of someone's social media account, and that's something to consider with your clients.
So, Sean, I think there's a question there from Jim. He submitted it through chat.
Okay. The question was, can you help an attorney search social media for information? The answer to that is absolutely. So, as I was mentioning, the searching through the social media information, we recommend gathering that data first, so you have a snapshot in time of that data, and then doing the search for the information that you have. So one thing that I hear every now and again is people recommending to clients of theirs to deactivate their social media accounts, and that's one thing that has come up in some cases where deactivating the social media account, and although the presumption was that Facebook held on to that data indefinitely, Facebook, at least currently, their standard is to delete it after 14 days. So by deactivating the account and Facebook deleting the information, you're opening up spoliation claims against your client, and especially if you're and there's instances of sanctions against not only the plaintiff but also the plaintiff's attorney directly for intentionally deleting Facebook information and things like pictures and things like that. So that's something to really be aware of. That Facebook is, if you deactivate your account, Facebook doesn't have an obligation to hold it, and they don't. And currently, their standard is 14 days. However, as we all know, anyone who uses systems like that, those rules are subject to change with minimal notice. So I wouldn't, even a year from now, who knows what what Facebook's standard will be. It could be immediate. We just don't know. So, and since they essentially own the servers and own the software, where anyone who uses it is up to their whim. So that's something to keep in mind when it comes to how you use and how you recommend your clients deal with their social media accounts when when a legal matter does come up. Privacy settings, they obviously, it's always helpful to keep the privacy settings as secure as possible, but I would definitely say never have a client delete that information. Now, obviously, a lot of these issues, even in light of the ABA expectation that attorneys have an understanding of technology, there's a lot of issues that just come with dealing with data in legal matters. So that may result in the need to bring in outside experts. So in terms of when to bring in outside experts, in my experience, the earlier that we're brought into a situation, the better. Although it doesn't always happen, but when experts are brought in again, just based on my experience, when we're brought into a case at a later date, there may have already been decisions made regarding e-discovery early on in terms of discovery orders, what was agreed upon by both parties that negatively affect the outcome that could have been avoided had we been brought in sooner. For instance, there's a current example of a case, North Star Marine v. Huffman. We don't have it on the screen here, but it's very recent, and the plaintiff attorney agreed to discovery, but didn't realize the cost that was going to be associated with what they agreed to. So they missed their discovery deadline by, I believe it was over a month, because they couldn't find a cost-effective solution to get and review all the data to produce it. So, and they never filed for an extension, and then the court wasn't very sympathetic. So they were ordered to find and produce the data immediately. So, but having an understanding of what it was going to entail earlier on would have greatly benefited them. E-discovery itself has been around for a while, and I think it's important to note that the industry itself has matured greatly in the 20 years that I've been in it. The technology has matured. There's a lot of different options in terms of tools. There's a lot of e-discovery consultants available, and a lot of information on the web regarding not only case law but also e-discovery practices that may be beneficial. There are some certifications that exist, and there's still more being developed. However, none of the certifications, regardless of what some of the marketing groups for those organizations say, none of them have come out as being the preeminent certification for e-discovery expertise, but those are being developed, and I think, again, that's a sign of a maturing industry. One thing of note, if anybody here practices in federal court for cases that have intensive e-discovery issues, the federal court system has their own group of e-discovery experts called special masters that they bring into the cases to manage those issues for the judges. So the judge essentially defers the e-discovery issues to the special master who works out any of those issues. And there may be, in some courts, will order parties to bring in outside experts to deal with e-discovery if they're not meeting their discovery obligations. Now, one of obviously the rule changes, as we mentioned, were a hot topic in e-discovery circles, but there's also a technology called predictive coding, which is the buzzword of the moment in the e-discovery landscape. So to kind of clarify, there's still a lot of questions about what it is. So to help clarify that, we're going to talk about it briefly. And I say talk about it briefly because although a lot of people talk about it, and it is a hot topic to discuss, in my experience, there's not a lot of people actually using it. So predictive coding, otherwise known as technology-assisted review or computer-assisted review, essentially it's artificial intelligence, similar to IBM's Watson that was on Jeopardy. The systems that exist are, and how the system works is a user will do a doc review on a small subset of documents and then feed those decisions back to the computer, and the computer will make suggestions on the remainder of the document set as to whether the document was relevant to the case, irrelevant to the case, and you can also do it for certain issues such as potentially privileged documents. Now, although the smart marketing guise that some of the companies that use it portray it as, almost like the Staples easy button. You press the button and the computer does the work and everything's done. It doesn't work that way. It's a workflow with multiple quality control steps that have to be performed by expert individuals. Statistical sampling is a heavy part of it to ensure that you're getting a statistically random sample set of the documents to go against. And it's a really process-intensive workflow. That's not to say that the technology isn't sophisticated and there in terms of the ability to really reduce the amount of documents that need to be reviewed. But I think there's a misconception in terms of how intensive that workflow is, and the importance of each of those steps along the way can't be discounted. Now, there's some cases where the courts have accepted its use. In most circles, again, I find that most people aren't using it. The largest cases, I think there's some immediate value there. As the systems that exist become easier to use and more understandable, I think we're going to see it become rolled into other e-discovery services as a filtering tool and also a prioritization tool in terms of the documents, where it'll suggest the documents to you to be reviewed first. But one of the issues related around predictive coding, just like with any new technology, is the cost. The cost of the technology itself is still fairly high. And if any of you deal with e-discovery currently, you can, if you decided to use predictive coding technology, you can expect there to be a few extra line items on your invoice related to it. But the true benefit against massive collections of documents is it can greatly reduce the manpower time of determining the relevant set of documents. So that's where the true savings is in the potential manpower savings of having to reduce all those documents, or to review all those documents. Now, before we go into an example of a tool that can help deal with some of these issues, we wanted to open the floor up to any questions based on what we discussed. So whether proportionality, whether social media, are there any questions?
And if you do have questions, please submit them through the chat feature. Otherwise, we'll go into the demonstration, and we can always field your questions as we go into that as well.
And we actually do have one question regarding how do you find a vendor? We talked about bringing in outside experts. How do you go about finding those experts, or finding a vendor to assist you with your data issues? There's a lot of different options out there in terms of vendors. The issue that we see, and there's a lot more consultants, independent consultants, both who are attorneys, who are technicians. The issue that we see, particularly when it comes to outside vendors and consultants, is cost. There's still a lack of understanding, and partly it's the vendor's fault in terms of what is an appropriate and fair price for the services that they're offering. Now, as I mentioned, it is a maturing profession. There's a lot of expertise that is involved in some of these issues. And some of the issues in terms of cost will depend, number one, again, on your case and what the needs of the case are. But I think it's also important to gather as much information as possible, and don't be afraid to do some research on who you're working with, or who you may potentially be working with to address these costs. and to look at the costs from multiple people. I think there's anyone, obviously with any profession, if anyone is hesitant to tell you how much something will be, it's something that may be you may need to be aware.
Maybe a red flag.
Yeah, that may be a red flag if someone's not willing to share what the costs are. But typically, it was a per unit a la carte cost were the standard for many years in the industry. We're seeing that change to flat fee arrangements or managed services arrangements, where a certain amount of services are provided on a monthly basis for a straight fee. And those are good options, especially the flat fee when it comes to having some predictability in terms of knowing what the final cost is going to be. However, I also caution people that some of the flat fee options that I've witnessed over the last couple of years since they've been adopted by some people, some of the flat fee arrangements can actually wind up costing more than the a la carte services would have cost from even those very same vendors. So that's something definitely to be aware of. Make sure that although you get the benefit of predictability with the flat fee, make sure that you're also not greatly overpaying for services because they just bundled everything into one big lump sum, and it may include services that you don't even need. So that's one thing to be aware of. So I don't see any other questions, so we will jump into the demo of our document review tool here. This tool is called In Control. It's a document review tool, and it's a really powerful tool in terms of managing your discovery documents. So whether it's documents that you need to review and produce to opposing counsel, or you receive from opposing counsel in discovery production, and you need to be able to search and review them for your own trial prep. A system like this can be very helpful. Now, one thing you'll notice is the system's all web-based. So all you have to do is log in via a web browser, so whether Internet Explorer or Google Chrome, and we put in our user credentials, and we can see that we're brought into our case here. Now, on the case is broken up into different sections. So on the left-hand side, we have folders for documents. So we have all the documents loaded into the case. We can see up here in the right-hand corner we have 4,901 documents associated with this current case. And we have it also subgrouped out here by custodian. Marie Hurd and Michael Magi are two custodians for this case. And in case anyone recognizes those names, this is the publicly available Enron data from the Enron bankruptcy. So this data is publicly available for general use.
Is there a limit to how many custodians can be on a case?
That's actually a great question. There is no limit to the number of custodians or actually the number of documents. So I've worked on cases where there were greater than 100 custodians, and cases that contained 60 million records, 60 million documents. So the cases, obviously, it doesn't. That's one end of the extreme, but also, depending on the needs of your case, the cost of systems like this have come down significantly. So even for smaller cases, systems like this can have a cost benefit. Again, in this case, there was just under 5,000 documents. And if you kind of do the math in terms of the average, when you do an average in terms of the documents and the page counts, you figure 5,000 documents, on average, you're looking at 5 or 6 pages per document. It can add up. So the ability to manage it in one central system, to do keyword searching on it, metadata searching on it can potentially be a game changer, especially for smaller firms, because many people are probably aware big firms have internal systems they use. They have internal teams on payroll to manage e-discovery. So with the advent of the quote cloud and systems like this, it really can level the playing field for the small and medium-sized firms. So if we, and again, to give an overview, we have our folders here. On the right here, we have all our list of documents. So we can actually see the document information in this grid. So it's just like a spreadsheet, just like you would be looking at a spreadsheet. And we can look at each individual document just by looking at clicking on the document itself. And it will bring us up to the document. In this case, it's an email from Sarah to Tom discussing some issues regarding an account. There's options. We can see that this document is clearly marked as responsive and privileged. And someone also noted in the notes here for a privilege that it was related to work product. So we can see the document here. And we can even just go and scroll through the documents to do our document review. Now, although you don't have the tactile feel of paper, it is paginated, so you do have that feel. And one benefit is all the information is stored right here in the system, so no one can walk off with the document. You can keep the tags on the documents here. You can apply issue tags that are all customizable. All these tags are customizable. We can put the documents into folders, so we can mark this document as responsive, confidential, and we can put it in our hot docs folder, so we know that that's an important document for our case. And we can even put notes into the system. This doc is hot, as a reference in the future. And the document field, again, is that metadata that we saw in that spreadsheet. This is a list of that metadata. So we can see it right here if we wanted to do a comparison between the document and the metadata itself. Now, if we want to save these tags, we can just hit the Save button, and it'll tell us we were successfully saved our document. So a couple other options that do provide some efficiencies. We have the ability to view duplicates of the document, and we also have the ability to see the full email threads of the document. So you can actually piece together, the full email conversation of the document. So you can see the entire conversation all at once. And that is helpful in terms of gaining efficiency and seeing the context of the communication. We'll close out the document and come back to the main screen here. Again, there's a lot of customizability involved in the entire system. So the fields here are completely customizable. So if we wanted to look at the dates or sort by date, we could sort those. We could remove fields, add fields, any fields that we wanted. Again, I mentioned one of the benefits of a tool like this and using a tool to manage your discovery documents is searching. So on the left-hand side, if I click on the search feature, I can actually search for words related to our case. So if I search for the words fraud or California, it turns out I have 48 hits. So there's 48 documents that either contains the word fraud or California in them. And there's different options in terms of searching. You can actually search on the metadata fields themselves. So we could also apply date restrictions. So if we just want to look at a certain date range. But one benefit of the keyword searching is the documents will highlight where the word was found. So in this case, we see the word fraud highlighted. We can see up here at the top we have a total of 3 hits in this document, and we can browse between the terms. And then to continue looking at the documents, we can just do the same thing, scroll. You can see we have the word California, there's 7 hits, and in the hit legend, we can actually see all the words that were found in this document. In this one document, we only have the word California. And we can scroll through the different hits and see we have more California hits there. And finding documents is as simple as that. So when we have the ability to perform OCR or optical character recognition on documents as we're prior to putting them into the system. So, for instance, if you had PDF documents or TIFF image documents that you received from opposing counsel during discovery, and they did not give them to you in a searchable format, prior to putting in a system like this, they could actually be made searchable so you could run those searches.
Sean, we have a question here from Jim, and his question is, if there is a missing email, can that go back into the email string?
Now, the missing email would need to be a part of the data collection. So once it's part of the data collection, the system on the back end will, so long as that metadata exists, will actually put it back into that email string. I did have a question from a client yesterday regarding deleted email. There was a case regarding that had deleted email and deleted documents were an issue in this case, and trying to retrieve deleted items. And one of the tricks with deleted items, whether it be email, text messages, Word documents, whatever it may be, is that all the deleted items may or may not be whole documents. So they could actually just be bits and pieces of a document. So even if you have a 5,000-word document that was deleted, there's the potential that only a few hundred of those words, depending on what had been overwritten, may be able to be retrieved. And that goes the same for the metadata. All the metadata fields, they're actually pieces of the document. So all of those, if you're dealing with deleted data, may not be able to be retrieved as well. And if that's the case, because the information on how we put together a system like this puts together the email thread information, it's using the metadata. So it's actually, and it's not just the subject line. I think that's a common misconception regarding threads. It's not just the subject line, because someone can change the subject line of an email when they forward it on or when they reply. But there's actually internal metadata to email that traces that conversation. And so long as that information that exists within the email that traces it together, the email thread can be created. There's options in a system like this. A lot of people like to share documents when it comes to using other parties on your case, whether co-counsel, other people in your office, or even experts. Users, you can give different users different login credentials. So say you want an expert to come in and look at medical records, you can give them a login to the records that you want them to see, and they can come in and make notes associated with those documents. And it limits them in terms of, you can limit in terms of what access they have and what functions they have access to in a system like this. So they wouldn't be able to edit documents or upload different documents to the system on their own. And that's to give some protection to you and your clients. And again, the system like this, like I said, is cloud-based and is available 24/7 through a web browser. You can just search and get it through whether on your iPad, laptop, desktop computer. Anything that's web accessible, that's one of the benefits of a system like this, is it's flexible and portable wherever you go without needing to tote around either paper or discs with your documents on them. So that's a brief demo of a system like this and some of the benefits that it can provide. So if there's any questions regarding the system, I'd love to take any questions if there are any. I do see one question in terms of specifically what other types of systems exist like this, and what is the cost structure on the use of systems like this. There's as with the maturing of the e-discovery industry, there's multiple options in terms of managing your documents. I still see some clients doing it the old-fashioned way with PDFs and paper, but systems like this, there's cloud-hosted systems, there's enterprise-level systems, and also there's desktop systems, like a tool like Concordance. The benefit of using a cloud-based system versus a tool that's desktop-based or enterprise-based, one is cost. The overhead cost essentially has been incurred for you, so there's no need to invest in any hardware or software. And usually it's the cost structure is a license fee on a monthly basis that usually for the cloud systems can be very advantageous for smaller firms. Enterprise level systems are the systems that you would see on the back end. So even a system like this that was sold into a firm for locally hosting on internal servers could be considered an enterprise system. And the cost to purchase and install, you could be looking at 6 figures to purchase and license the software, as well as in some of the huge system that's managing multiple cases of millions and millions of records, you could be looking at hardware costs in the high 6 figures as well. And although in the desktop options, the cost is just a matter of licensing the software, I think it has to be noted that those tools need to be managed as well. So the loading of the data, the indexing of the data into those systems, exporting data out of those systems are all things that need to be considered when it comes to these issues and dealing with any document review systems. And I think and those items, although for someone who's technically savvy may be able to manage that, it can be complicated in certain issues. So I don't see any further questions. So I want to, again, thank you all for your time today, and I'll turn it back over to Carol.
Thank you very much, Sean. I really appreciate your time, and I'm sure all of our attendees also thank you for sharing this very valuable information. That concludes our webinar today. If you have need for an expert witness, or if you would like to speak with Sean more extensively about e-discovery, please give us a call here at TASA. Our number is 1-800-523-2319, and we can be reached during the day and up to 8 o'clock in the evening. And I thank you again for your time, and that concludes our webinar for today.